of Appeals. Town offices, 50 Billrica Road, Chelmsford, room 204. Public input. Public input shall be limited to statements from the public relating to any issues with the jurisdiction of the Chelmsford Zoning Board of Appeals that are not currently the subject of a pending public hearing before the Zoning Board of Appeals. Public comment on any pending public hearing shall only be heard during such public hearings. We have a continued public hearing tonight, 43 Bartlett Street. Elizabeth Gavriel, trustee, requesting an administrative appeal of the building commissioner's determination letter and a special permit under section 195.61 for a pre-existing detached limited accessory apartment, LAA, and any other relief deemed necessary. This property is located in the residential RB district as parcel ID map 94, block 352, lot 1. Good evening.
Good evening. For the record, Doug Hausler from Lampert, Hausler, and Rodman, representing Elizabeth Gabriel, who is the owner as a trustee of the property at 43 Bartlett Street. I'm not sure how many of the members were here when we first appeared back in July or August about this. So if they want a recap, I'll do that. If you don't feel like you need a recap, I'll pass right by it. So it's a matter of board members.
I'm good, yeah. I'm okay.
Okay, great. So I don't want to repeat history here. It took us a while, but we finally obtained an engineer, civil engineer, as well as a licensed individual with a backhoe to dig down and check the soils that were the reasons why we can't connect another, I'll say, dwelling space, which the limited accessory apartment bylaw usually requires. This is the unique application, as I probably said months ago. This was a pre-existing structure that was converted in part, one bay out of threes, into a limited accessory apartment in 1990, 91, something like that, and has been used continuously since then in that fashion. It was not an unknown to the town. We provided documentation that showed the sewer commission allowed it to be tied into the house's sewer line and approved of it and actually monitored the construction of it, specifically because of the limited accessory apartment. In addition to that, I think the water district did the same exact process. So this notion that it was just hidden from the town is just not true. It was there. The reason it probably wasn't noticed by anybody was because of the pictures that I provided at the last meeting, which are already a part of your record. This particular apartment is so hidden you cannot see it from the street. It's all the way up the driveway, and it's actually to the far right of the garage. So looking from the street, you might see one or two garage bays, but you see nothing of the third. So if you're looking from the street, you think you got a single-family home with two cars garaged. It has additional bituminous area for parking, so we have adequate parking, and that I don't think anybody was questioning that. When last we were here, I had asked about getting if the board had the power to waive certain of its requirements of the bylaw. And we asked that town council provide an opinion, which it did on January 26th, and I'm very grateful to Paul for having wrote that and investigated it. And I agreed with what he concluded, which was that the board has discretion to waive certain of the requirements that we've asked about. The other reason I think waivers are appropriate here is this is an incredibly unique situation. This was in use before there was a limited accessory apartment bylaw. This was, so it's essentially pre-existing, non-conforming. That being said, the bylaw itself, you need to reconcile what's the intent of the bylaw versus the practical of what's on the ground. And anybody that reads the bylaw, they see the words shall give this and shall file this and shall file that. such as architectural drawings and identification of, the square footage and plans and design elements, architectural design elements. None of those are really applicable here. The building's already been built. It's been built for 30 years without problems. No one's complained of the type of structure or architectural issues with it. It's completely hidden by well-matured plants and trees. We go past that. Then you go to the issue of, is it under 750 square feet? We demonstrated that it is. I believe Jose once went out there to inspect, and I think he could attest, it's under 750 square feet. So all of the actual requirements of the bylaw are pre-existing and satisfied. So why would you compel a resident to spend literally thousands of dollars trying to get architectural plans of something that already exists that you can see on the ground? It's better than architectural drawings. You have reality. Number two, you can walk through it. It's under the 750 square feet. Number three, it's hidden from view and does not change the character of the neighborhood in any way, shape, or form, regardless of any arguments that have been asserted to the contrary. So the biggest issue that was facing this board when I appeared the first time was, well, the bylaw says it has to be attached. Well, that's what the bylaw says, but the fact is, we couldn't attach it. The garage was pre-existing. The surveying work, not surveying work, excuse me, the groundwork, earthwork that we provided through the report of the engineer demonstrates that if we were to try to pour a foundation and attach another structure to the existing house, we would be hitting ledge all over the place. The garage was built at the same time as the house, so this was not something that's been done in the last 10 or 20 years as a new structure. It's always been there. I think the garage itself has been there for more than 45 or 50 years, much like the house. So I just think you need to apply common sense to the intent of the bylaw, which was to make sure the character of the neighborhood is not being violated in terms of its architectural issues or privacy issues. It speaks for itself in terms of being exactly what a LAA should be. Not one neighbor who is either a direct abutter or other than one across the street who's here this evening, who has no vision, can't see straight ahead into it, has no idea that it's back there, only sees the front of the single-family home. So from an appearance viewpoint, I don't believe that abutter has any legal standing because none of its interests are impacted if you grant the waiver. There's no standing, there's no injury, there's no damage, there's no harm. It's not challenging his privacy, it's not challenging anything. It's just going forward on the basis of common sense. I ask that you consider the waivers, that you not require us to go through every single provision of the bylaw in this instance and waive those requirements, given the incredibly unique circumstances of this application. You had asked us to provide some evidence about the soils, which would support a variance if we really needed to go down that far. We did. I really don't think we should have to file for a variance. I think it's something that's within your discretion under the bylaw. There's no question that the structure itself is not violating any part of the bylaw. It is the use that's being challenged because there was no original permit granted for the LAA use. The structure is fine. I believe the building commissioner can confirm that. So we're talking about use. That's it, no more and no less. And I'm happy to answer any questions that any of the members of the board may have.
You go ahead. I think you can just go.
Oh, please, go ahead.
A question.
Sure.
In the picture that's up there,
Yes,
the area that juts forward,
yes,
I assume is part of the LAA.
that is the LAA.
And in all the documentation, it talks about that it was a three-car garage that was converted. And when you say that, it's implied that it was a rectangular structure of 3 bays. obviously, it was expanded well beyond,
It wasn't a three-bay garage in the sense you're thinking of. It was an L.
it was an L.
Yes.
So where that boxed window is in the front, was that where the door was, or on the side?
Originally, you could drive in and pull in.
On the side?
On the side, you just come up and pull right in. And there was
Well, if
already-
you could pull to the side
Yeah, here,
from there,
yes.
it doesn't look wide enough to hold a car.
Oh, my God, there's plenty of.
No, I'm talking about the structure itself.
The width, you're saying?
If you were to, there's 3 windows on the side.
Yes.
Is that where the door was?
There was a garage door there originally.
All right. But if you were to go in there with a car,
Yes,
it doesn't look like it's wide enough to hold a car.
it was because they did use it that way for years. Then they converted it when Mr. Gabriel's mother needed to live with them, and they converted it. That's the answer to the question. They absolutely used it as a 3-car garage. Because originally, she was allowed to drive at her age, so she had a car there. And then they converted, they had a 3-car garage for themselves. She needed to move in. They created the space by literally blocking off the 1-bay garage. And then because of the rear of, what I'll call the 2 bays, had a little extra space to it. So it was a perfect fit for being under 750 square feet.
And what about the piece that juts out on the front edge, on the lower portion up there? Was that added to the existing garage? If you just go back to one,
Sorry.
Hold on one second.
right there, that piece on the right.
This?
Yes, that area.
I'm not sure what that,
That wall's about 18 feet according to the town
yeah.
tax map. That wall is 18 feet long. The
Okay.
garage door is about 8, maybe 9 feet wide.
And what about the appendage to the right?
This area?
Yeah, is that part of the existing unit now?
I don't believe so.
The UST and CAN, I don't know what that stands
Underground
for.
storage tank or
Oh,
something?
CAN is a canopy,
Canopy, yeah.
and
that makes
UST
more
is
sense.
utility
I think there was a
storage
patio.
unfinished.
Yeah, it was a patio area.
And I have a question to town council. In the documentation, it talks about arbitrary and capricious. Is there an English definition of that?
There is certainly a lot of case law that interprets whether a particular decision by a board is arbitrary and capricious. It's sort of the standard for reviewing a board's decision. But ultimately, in this instance, when I used that language in my letter, what I'm stating is that when the board is choosing whether or not to grant a waiver of the submittal requirements, that there has to be, there has to be a reason why you're granting it. You have to be able to point to something that makes the requirement for that submittal not necessary.
It still seems like it's in the eyes of the beholder.
Again, there's a reason why there is a lot of case law reviewing a question of whether boards' decisions are arbitrary and capricious, because ultimately it is a case-by-case basis.
Okay. Question for Attorney Hauser. In the documentation, there was a diagram that they had dug down 29 inches, I think, before they hit ledge. And that if you were putting in a foundation, you'd have to blast, and that might affect the house.
Oh, yeah.
But why do they have to put in a basement to connect it to the house?
The requirement would be for a 4-foot foundation.
Yeah, that's a
but
building
not a
code issue.
basement, but it has to go 4 feet in the ground.
Couldn't it be a slab?
The foundation is required, we can ask Jose, but
I think,
foundation is
that was
required.
my understanding, had to go down 4 feet.
And you can pin it to the ledge, obviously.
You cannot pin it to the ledge. That's why it's difficult here. The situation was difficult. There was a reason why they didn't try to add it to the existing house way back when.
So, Jose, you say it can't be a slab?
What is the distance?
I mean, there are a lot of slab ranches in town.
What is the distance from the house from the garage?
25 feet, maybe 30. I guess, let me answer the question, turn it around if I may. As a practical matter, would you make someone who has what is otherwise a fully compliant apartment rebuild that apartment just to attach it to the house?
That's what the town ordinance is.
It does if you're building new. You're not building new here. That's what the bylaw is intended to do.
No,
You
we have forced people to attach a detached unit to the house so that it complies with the letter. For example, the red one with the guy with the garage beside it, we made him connect it to the house.
Disassemble a second apartment, and it was quite a ways, too. So.
Was it around for 30 years like this one was? Was it around with the
It
town's
was a
knowledge?
barn. It was actually a barn.
And he had it as an apartment?
Yeah, 2 apartments.
2, all right. Well, was it still an accessory apartment, or was it more than 750 square feet?
Not, the details, I can't really remember exact square footage, but what it basically was very similar to what here. Someone was
Would have
living
been
in it.
oversized if
Yeah.
both apartments.
Yeah, so they scaled it to 1
Mm-hmm.
and then connected it to the ranch. But it was an old barn that was there. I don't know how long that barn was
And
there.
I don't know if it had similar soil conditions or,
Yeah.
limitations like we have here. So I think it's probably
Well, in this case, it
distinguishable.
was, I think it's just a walkway that connected it. It wasn't,
Yeah, but-
wasn't any major,
So it's, yeah,
yeah,
which did not require a foundation.
no, right.
So, I mean, but then again, to answer a question, what's the practical reason for doing it? Other than the bylaw intends for it, generally when you're building a new unit, a new apartment, you have to comply and it's supposed to be attached. I don't argue that point.
I don't disagree with your logic of why does it. And the board has talked from time to time about proposing some changes to the language. But the language isn't changed right now. The language is the language.
But the language has to be interpreted in accordance with the practical realities you're facing. You don't apply a statute or a regulation just because the regulation exists. It has to have a purpose. The regulation is to have a purpose. In this instance, it doesn't serve any purpose. It's otherwise fully compliant.
Was there a building permit pulled on this when it was originally, do you have a?
No.
No. So
That's
there was
why
no
we're here.
building
It's the only
permit.
reason why we're here.
Yeah,
The structure was pre-existing.
right.
The use was not.
But the construction of the LAA was a
The
permitted?
interior,
Was that permitted?
no.
Okay.
But it wasn't permitted by an issuance of the building commissioner back in 1990-something. But the town was fully aware of it and allowed it to be connected to multiple systems. Even utility companies allowed it to be
Did
done
they
through the
run
house.
water lines and sewer lines to
Yeah.
it and everything? Okay.
And I gave the proof that the town actually was fully aware of it.
So they got those through the ledge over there.
They,
I mean, you gotta go, what, 4 feet, right, Brian? Isn't that code?
I
4
think
feet?
they came up through the
42.
driveway.
Less,
Oh, for
less
water.
for electric.
Water is 42, isn't it?
Yeah, they encountered a lot of trouble getting those
Yeah.
lines in. I don't disagree with you, but
Right.
I guess my point is, it was no secret to the town.
Yeah.
And I have to get back to the basics, which is, who's harmed?
Yeah.
I don't think anyone would have standing to challenge a decision legitimately. Can somebody challenge it? Of course, there's a possibility that there's going to be some lawyer out there that wants to challenge it on behalf of a client. Someone who may disagree with my position.
Yeah.
Good luck. I'm not worried about it. I'm happy to deal with that in a court if necessary. But I don't see that they're going to be able to qualify as having any harm by waivers being granted in this particular instance. It's not precedent setting. It's completely unique. Arbitrary and capricious standard is fact, case by case, fact by fact. So,
I don't think, I may be wrong, I don't think the people who wrote the language for LAAs anticipated us applying arbitrary and capricious to what they wrote. And we have done our best, as long as I've been here, to try to live within the rules as they were written.
Can I clarify this issue? Because
Please.
I do have to disagree with Attorney Hausler on one of his points. I thought the reason that we wound up continuing this previously was because the applicant was going to come in and seek a variance. And I thought that was why the geotechnical information was being provided.
For
As it-
the soil conditions.
Yes,
And as it applies to the issue of connecting the building, because that is not one of the dimensional requirements under subsection D, the design standards. That is actually within a different portion, it's actually in multiple places elsewhere in the LAA bylaw. I do not think that you have the right to waive that requirement, because that is essentially, and I'm going to disagree with Attorney Hausler again to an extent, it's not a use requirement, it's a dimensional requirement. In that, so the need to get the LAA approval is a use requirement, right? And they need the special permit from you for the LAA use. But the requirement for connecting it to the structure is a dimensional requirement. You have the potential right to grant a variance for that dimensional requirement based upon whether or not they meet the standards under Chapter 48, Section 10 for the grant of a variance. But I don't think you have the right to waive it, and therefore, the arbitrary and capricious doesn't go to that question, because I don't think that under a special permit waiver or anything of that nature, there's nothing in the bylaw that grants you that right to grant that waiver.
Asking for a waiver for,
So the letter that I submitted addresses waivers of submittal requirements. And that's when I'm talking about arbitrary and capricious. What I was saying in there was, you have the inherent right to waive a submittal requirement, which is not a dimensional requirement or something of that nature, if in particular circumstances, meeting that requirement doesn't make any sense. And that's where the arbitrary and capricious standard would come in. If you're granting a waiver from requirement to meet, a submittal requirement, does it make any sense? Is there an actual reason for why you're granting that waiver? Is it related to the nature of this request? And you can't just grant waivers left and right. And certainly looking at some of the submittal requirements, I have to go and find where they are. But there's a requirement that you have to identify the people that are going to be living there. You have to provide, what is it, a restriction? There are certain waivers, there are certain procedural requirements that I don't think you would have discretion to waive, because they're fundamental to the bylaw. The question is whether or not the requirement for the submittal of an architectural plan is really fundamental to the bylaw when there is no actual new construction being proposed. That there's something that already exists on the ground that you could simply review. You don't need an architectural plan.
granting a waiver for that would be acceptable, you feel?
That I think is something that, could be within your discretion. Because it's a procedural requirement that may or may not really be necessary in this instance. But as it relates to the actual substantive requirements, you're only allowed to waive those provisions that the bylaw states that you can waive. And here it's the design standards under subsection D. And the requirement for it to be physically connected to the existing structure is not within those design standards.
so we'll apply for a variance.
And that's fine. I wanted to clarify.
Oh,
Because I was
thought
under the
that was
impression
the
that
intent.
you were,
I thought they
that
were
you had
following.
filed for a variance.
I was gonna see if it could be waived. It was a question in my mind whether it could or could not.
Yeah. And I thought.
I'm
we
happy to
cleared
make
that
the
up last
board
time.
satisfied that if you want a variance standard, I've already given you the information that's gonna support the variance. So I'll go through the process of filing a variance application and providing the notice through the office. I have no problem with
I recall a
that.
short discussion last time that you were going to come back with a request for a variance.
And when I was researching, I had come to a different conclusion than town council. I thought it was within the purview of the board's powers and authority in this type of situation to grant a waiver. I'm not looking to make new law. So I will now, I thought you could waive it, and that's how I wanted to go forward. I wanted to get back before the board. I wanted to give you the information I thought you would need. I've heard the board, I've heard town council very loud and clear. I'll come back for a variance standard. And although variances are rarely granted or supportable, in this instance, I think we're gonna hit every single one of the criteria here. Because the issue is relating to the soils being able to connect the building. So it's gonna absolutely meet the definition of a variance. That's usually the hardest part, the hardship associated with the land. In this case, we've got it.
I have another question. Again, your letter was written, well-written from a legal standpoint. I'm not a legal person, so maybe I misinterpreted wrong. But in the next to the last paragraph on your third page, it says presumably, the LAA included a provision that it be physically attached to the existing single-family home to avoid having multiple separate structures on a single lot. Here, however, the structures have been pre-existing. There has always been a multi-car garage with a separate single-family home. Nothing new is being constructed to create a new standalone building.
No new construction.
But if we were to agree to that, would we not be opening it up to every single piece of property in Chelmsford that has an existing place on it to do the same thing, that it doesn't need to be attached?
Well, the precedent is not
Right.
a requirement we follow. Each one is an individual decision, each application. But precedent exists, obviously, and it would certainly be for someone to say, well, he did it, why can't I? But we are not obligated to follow precedent.
And
Well, if we
But
should-
we would be
individual
creating
decision.
precedent.
If we move forward with an LAA, it could be precedent setting, but if you move with a variance, like you were saying, it's a result of the quality of the land.
that's why it's gonna be
And
distinguishable.
that's clearly something that falls within the ZBA.
Absolutely.
And I'm happy to do it to avoid the problem that you're raising. I have no problem with that, but I don't want to go through all that time, energy, and expense and then be told the variance isn't likely to be granted. I'm trying to get a read of the tea leaves here.
I don't want to get ahead of the process, but do we need a formal request for a variance? Or
No,
can
I
you
have
just-
to file.
You would have to file a formal request for a variance, and more importantly,
Oh, for
it
public
would have to
meeting,
be
yeah.
publicly noticed.
Right.
Right.
Yeah, absolutely, sorry.
So
Absolutely.
there are circumstances, I'm sure the board is aware of times where an applicant has come in seeking a variance, and you've been able to move forward with a special permit because that's a lower form of relief.
I'd just like to send you home with
I-
what you
No,
want.
that's
When-
fine. I was.
When the meeting was noticed for a special permit, you can't grant a variance.
I want to ask a question that I suspect
And
has
this was
already
just
been
an appeal
answered.
with the building commissioner's letter.
I'm sorry.
It's not a special
And a request for a
permit either.
special
It was both.
Oh, it was a special
It was
permit?
both. It was an appeal
And a
and.
The
special
footprint hasn't changed.
Not at
Since
all.
the original structure.
That's correct.
I think you said that, but I was,
Yeah, no,
Not,
you're right.
not really
not
here.
since the original structure, since the dwelling unit was created.
The dwelling
The
unit is
original
never,
structure was a three-car garage, correct?
yeah, only the interior of the LAA
Yeah,
has been
that's what I
changed.
was asking, the
But
footprint.
no expansion of the footprint.
Yeah, you didn't turn, yeah, like you said, the third car turns in.
Turned in.
But if it had been this way, 1, 2, 3, then you would have added
By
something.
doing it this way, they maintained a backyard.
Gotcha.
Is there pictures to the right where that jets out like,
I don't believe so.
is anyone?
Question. Oh, I was looking for that,
I
I
don't
didn't
think
see
so.
anything.
No. I was looking at some older pictures
All
on
we
the
have is-
interior, and it looks like the kitchen is in that portion.
It's in the, right when you walk in, the kitchen's in the very, from the entrance way in. I don't know if you, there's
I'm
gotta be
going
a
back
picture
to
there.
there.
Yeah, there's tons of pictures, I know.
Yeah, I know, I tried to be thorough.
Yeah.
Thank you, Becky, for doing this.
What had happened was the photos got split in two. The first time we posted it, for whatever reason, the exterior of the LAA didn't get scanned in. So then I created that newer one where it says exterior, so.
Right, so, but this, can you stop right there
Yep.
for a second? This is what I was trying to say about the character of the neighborhood. This is the perfect example. There is no way you have any knowledge from a street view that there's an LAA behind, essentially behind here.
Well,
You can't see it.
Well, you indicated in your third paragraph that the pictures provided previously demonstrate the LAA is entirely removed from view of any abutter, given its location in the rear of the lot and behind the existing single-family home.
That's correct.
There's mature trees and plants that buffer the LAA view from any butter. But the question for town council is, it doesn't say, who cares? whether it's seen or not seen from us making any decision.
Yes, it is. It's part of the intent and derogation from the intent of the bylaw, which is one of the three characteristics you have to meet for a variance or for a special permit, actually.
That we don't see it?
Not that you don't see it, that it doesn't,
That the grant of the variance
Grant
does
of the
not
variance or the-
derogate from the intent of the bylaw.
that's, all I'm trying to say is, if you look at it, you don't get a sense that it's a multi-family house. You think of it as a single-family house, which is exactly what the intent of the bylaw is.
So if we were to see anything where someone was trying to convert a single family into a two-family, if you couldn't see that it was a two-family, that would be okay?
No.
No, I don't.
In other words, we can't see that there's two units there. And if they were to take a couple of rooms in the house and make that an LAA, now, you couldn't see it from the street.
Then they could do that as
But
of
can you,
right. through the
are you
building
making can you make the argument that, well, it's perfectly okay because you can't see it from the street?
But it does add stress on the services,
In
you know,
the
sewer,
single
water.
That would not require relief from the board, actually.
Yeah, that's
The
fine.
building commissioner could allow that.
Never would come before the board.
I guess the
A
way,
situation like that would never come before the board.
Never. It's all interior of the existing single-family home.
So if you look at section 195-6.1, C, applicability, eligibility, the building inspector may issue a permit by right for an LAA based upon the following criteria. The LAA is located within and as existing, as of the date of application, owner-occupied, single-family property located within a zoning district. And B, the LAA is located within the existing dwelling unit, inclusive of legal nonconforming structures. So as long as you're doing that LAA within the existing unit and not adding on, you're allowed to do that as of right. No need for relief from the Board of Appeals. It's only when they're seeking to expand upon the building that the special permit is required.
Did the garage get a permit when it was?
It's part of the original, yeah.
Did you?
Oh, it did? The garage
The
had
garage
a
itself was
Yeah.
a part of the original
permitting process.
permit.
When it was a three-car garage.
base.
As a three-car garage.
But I guess from a
I-
logical point of view, if I built a three-car garage in the back of my place that's legal, if I wanted to keep it a three-car garage and put windows and whatever on it, it can look like whatever it looks like, and it would still be legal if I'm not using it as a LAA. So the appearance is what it is, so whether you can see it from the street or not, it's already there. It was legal to have a building there, and if they wanted to put a basketball hoop on it and paint it pink, then it's,
Perfectly okay?
yeah.
I'm curious, do you have any communication from the abutters at 49 and 39?
Totally in support. Everybody except Mr. Harvey who's in support of this. Which makes me feel that I have a good chance of prevailing, because it's only one against everybody, but that's okay, that's what courts are for. I don't wear the robes.
No comment.
The judge will, if it gets challenged, the judge will make those determinations. So unless there's significant questions, can I go forward with the variance application with the sense that we're going in the right direction? Or do or is there any other issues that you're considering that you'd like me to get addressed ahead of time?
The place where they dug this test hole, was that at the corner of the house that would be connected to the garage?
Yes. It was in the exact areas where the logical connection would be.
Is that the X that's there? Yeah.
Yep.
There, yeah.
And maybe Jose can speak to it. If you built some sort of structure to the house at that point, and it was built on a slab, is it okay?
In order to connect it, I mean, there are many ways to, to connect the structure to the main house. It is upon the registered design profession to determine which way to go about, whether they want to use a slab on grade, and of course, everything's going to be according to the building code. It's got to be insulated, everything's got to be built. That portion will need to comply to the current building code. But there are many ways to go about to connect these structures if the conditions permit. Per Mr. Hausler's testimony regarding ledge and all these conditions, it might not be possible. But if it's possible, then it will be upon the design professional to determine. All we can do is really review and if they're approve or disapprove the building permit application based on the plans presented to us. But I think that will be more for the design professional to determine how he or she is gonna go out to connect the two structures.
Wasn't that part of the original request, to put a breezeway in there? Or you
I
had
said we
drawn of a
could.
breezeway and said it wasn't feasible?
It really, it doesn't make any real practical sense. It's expensive, number one, and very expensive. And number two, it doesn't serve any purpose other than to physically attach it. I'd rather go the variance route, because I think it's a strong argument for a change, for a variance, get it approved. Because I don't have to show that it's impossible to do anything else. I just need to show that the variance standards are met. And I think, if I'm wrong, you can tell me, Paul, but I think that's the requirement.
Here's the type of question I'm famous for, because I'm clueless. That picture right there would suggest that the lot line cuts right through it. Am I reading that right?
You are, based on that map, yes. That's an assessor's map.
Oh, okay.
My clients have had this, they've had control over this whole area for 50-plus years.
Deeded?
I don't know about deed or not. They have this, they didn't do a full survey. I can get a plot plan. I think that they crossed over way back when they were building it. This is all mature trees.
Yeah, I
No
saw it.
neighbors have ever complained.
That was supposed to be a street at one time,
I
right?
think it was, but it never got built. So this is what's gonna this is probably an adverse possession claim. No one's ever challenged it, and I'm not trying to,
How long have they had that property?
50-plus years.
So that would be adverse.
It would be, I didn't go forward with a formal adjudication of a lot line. I didn't need to. No one's challenging it. None of the neighbors who got notice of this are challenging it, including the neighbors behind them.
That
Okay,
may,
no, I
that may
understand how
change
that works.
based on the participation in this meeting, it looks like, but.
Good?
My neighbor had a plot of land for years. There was a full acre they didn't own. After a while, they just put it under their name.
Can't answer that one.
Seriously. Seriously.
Sounds like good business for Paul and for me, but
Well, this goes back 40 years.
After the discussion, my biggest problem still comes back to the fact that we made someone connect his side building to his house before we would agree to it. And in this case, we're saying the complete opposite.
Well,
that
he
they don't
didn't
have to
apply
do it.
for a variance otherwise, in that case. He didn't apply for a variance. I think, if I'm not mistaken, the variance would allow him to not connect.
Correct.
That is something we could grant as a variance. The waivers he's requesting are completely different and a little concerning to me because we don't even know if this house is on his own property because we don't have a certified plot plan. So it's problematic. The waivers are as problematic as the variance. I mean,
Yeah.
I think the variance has its own concerns. I think there are unique circumstances, being that it's completely built, it's there, and there is, I believe, ledge there. I think it's fairly obvious from the outcroppings that are there, as well as the test holes that were dug. That's an engineer's stamp on that, so they were dug and they were observed. That is a qualification for a variance. So to grant the variance based on that, but are we going on a building that isn't even on the property is challenging to me.
Then we'll get a survey done, and if I have to commence an adverse possession claim, I will. The other way I can do that is I can talk to that neighbor, if the neighbor so desires, and get an easement. Either way, it's gonna be solved.
Well, I mean, you could either call it grandfathered in or adverse possession.
I'm trying to avoid the litigation.
What occurs to me is we're so worried about causing a burden to the town. What about a burden to the owners of the property to attach it to their building? I mean, does that come into play at all? You know, I can see a bill for $70,000-$80,000 just to
To connect
make it
it.
appear to connect.
That's exactly right.
Well, that's part of the standard for the hardship.
Fair, but that's for an LAA.
No, so that's the standard for the grant of a variance,
Okay.
as to whether or not
Okay,
there,
yep,
there
you're right.
is a hardship, financial or otherwise, related to lot shape, soil conditions, or,
You're on the right, I can't remember.
Lot shape.
My mind's
Soil
blank.
Soils,
conditions.
Soil conditions
and
Topography.
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 Yes.
Those are three.
But according to Jose, he doesn't know what would be determined by whoever's going to do the work, if you could put in a slab or not.
I believe there are ways that you could connect this without affecting the ledge. Is it financially feasible? You know, you could do literally a bridge that would, you know, walk you over it. Is this structure have to be heated? If it doesn't need to be insulated. So there are ways to consider attaching it that don't, I don't know that it would require heat. I don't know that that's actually part of the attachment. If it is more of a covered walkway,
Like a
is it
bridge,
connected?
a bridge or a breezeway.
If even it's a
would be-
breezeway,
would-
that's
would
enclosed.
damage
But
the
my only
property
point
line.
is, we're not gonna have to go down any of that. If
Yeah.
I apply for the variance, all those issues are moot. I'll get a plot plan. That's just the assessor's map.
Yeah,
just
no,
did-
I understand that clearly.
No, 'cause the reason I say that-
I'm not trying to be another obstacle. I just, it's concerning to say we're gonna grant, allow this building to be there when it's even not legally on property, and we don't even really have an owner, whether, maybe it's the town, maybe it's, by default theirs.
Get you an answer, Brian.
Okay, I appreciate it.
Now I feel bad I brought it up.
No, no, that's fine.
It's
If
a
that's a
process.
concern, it's a process. Other than that issue, were there any other issues?
The way I'm looking at it is, we're not changing the character of the neighborhood at all.
Oh, no. Okay, if there's none other, I'd ask for this to remain open
Open up for public comment.
until we get the variance issue decided. Then if the variance issue is decided, I can probably just get a new permit and we can moot out the whole challenge to the administrative process.
I'm gonna honestly say, I don't think we don't have any idea of whether everyone is in favor of a
I didn't
variance.
say, I know, I understand.
To be clear.
But process, I'll file for the actual variance, because that's what the board prefers, and I get town council's viewpoint on this entirely.
Do you see that being problematic, Paul, if we were to grant a variance? Are we looking at other issues, or?
Well, I don't want, with all due respect, I don't want anybody to make an opinion yet, because I haven't even presented for a variance yet,
Fair enough.
officially. So I don't want to, I'm not trying to get a straw poll, really. I'm just trying to make sure I'm addressing any issues that are in your minds, such as the lot line issue. Those are the things I want to know so I can address them.
What is the address of the other property
The rear?
in the rear there, where, that?
Off the top of my head, I don't know.
I
Is
can
that
tell
9
you,
King Street?
9 King Street.
Okay.
The lines don't even meet. Well, that's where the
That's
street
because
was
that was the
supposed to go?
paper road.
Gotcha.
But
The property behind it is 9 King, but there is a delineated paper road.
Just doesn't go all the way.
I'll just get out the titles and
It's
plow
all
through
over
it.
New England.
Right.
So I would, if it's okay with the board, I'll ask for a continuance for a period of 60 days. I will try to get my application for a variance in within the next week. I have a trial next week on Monday and Tuesday, but I can get it in by next week.
April 4th.
So you could have it heard perhaps in, I don't know if you're having another meeting in February or you'll do it in the first week of March. Probably the first week of March.
30 days.
30 days. No, I'm asking for 60, Brian, because I'm going to file the variance to have it heard.
You were right.
So to be April 4th will be 60 days.
Yes,
Okay.
sorry, I
No worries.
misunderstood.
Okay, I am gonna open this up to, public comment at this time, and, we'll move forward with the, next phase.
Thank you very much for your time.
Anyone here that'd like to speak in favor or opposition to this application?
Good evening, members of the board. My name is William Harvey, 36 Bartlett Street. Is it okay for me to ask a question to the building inspector?
I think so.
It was just relative to his testimony earlier.
Here's what I found.
Relative to the connection of the garage to the house, you stated that it would have to be to the current building code, is that correct?
That's what I say, yeah.
Okay. And with regards to the illegal dwelling, that was never, there was never a building permit issued on that, and there was never a certificate of occupancy issued. And it's always been an illegal use under zoning in the town. Would that also have to be brought up to the 2024 building code regulations and standards?
If approved as an LLA, yes.
Thank you very much. It's very expensive.
I get the threat, I understand. I don't think it's funny, but I get the threat.
We'll do a small claims trial next week.
No further comments.
I'm not going against you. You would do small claims, definitely.
Could I ask for a motion to continue until April 4th?
Motion to continue the public hearing for 43 Bartlett Street.
By Steve, a second. By Glenn. All in favor?
Aye.
Thank you again for your time. Appreciate it.
Have a good evening.
Have a good evening.
I'll pay for it. I'll pay for it. Oh, you know what? They don't have light beer. Put your stomach in. Look at this guy instead. Like Santa Claus.
Okay, what are we doing now?
Figure that out.
Santa Claus has left the building.
I think we're going to approve some minutes. And are we going to take on the LAA a little more in depth tonight?
When do we need to, is this going to town meeting?
At this point, it has not moved ahead in that fashion at all. I think in order to make changes to this, we would have to approach planning board, go through that process, the select board, and then to town meeting.
So it's a year or more away, really?
Or
I mean-
to create a committee of various groups that are also should weigh in.
And I'm sure we don't have the purview to create a group. Would that be something that Paul Cohen or the select board would approve, Paul?
It could be, yes.
To approach them to create a committee to work on this, is that how that would be?
So what exactly, what would you presume is going to be the makeup of that committee? Are you looking for a member of the select board, maybe a member of the planning board?
The housing
Advisory
affordability and,
Board.
The zoning board of appeals, the planning board, the Chelmsford Housing Authority, the Housing Advisory Board, the Council of Aging Board, and representatives from the community at large.
Okay, yeah, that would definitely be something that would have to be created by the select board, or by the town manager.
So, I mean.
But someone would have to
This
go.
is certainly your thoughts on this. Glenn, do you want to pursue that, to try to create that committee? Is that,
Well, I would think that the chairman of this board could go to all these groups. You know, I'm certainly willing to do it if appointed. I just can't go do it on my own.
I think the first group you would want to go to would be the select board.
I mean, you have my support if you want to go to the select board. We can make a motion to, if that's feasible, to go there reading through your items, there's some that I definitely don't agree with, but I think that, you know, creating a board to look at it is a start. We certainly didn't have too much success last time we tried to make a zoning change, so that
But
might be the
what
way
we,
to do
what
it.
we did find the last time we talked about it was that it's like a tree. You start with the trunk, but as you keep getting into it, the branches, you keep being let out on more and more branches that have questions.
Absolutely.
And the more people who have some interest in it would bring not only those, maybe those questions, but additional questions, so that the end result of whatever is put together is the best solution based on their collective input.
Do we know what people are looking for? I mean, did this just come up out of the blue, that, take a look at the LLA regs?
Oh, it came up, I think there was a need. We talked about expanding it in our little group. We talked about expanding the footprint from 750 to a larger number. We decided with the waivers, we already have that right, we have that privilege to say that we don't think 750 is enough. I mean, my personal belief is in a single unit, 750 is probably suitable. But when you put two people in there, and typically elderly people who sleep in separate bedrooms, it's very tight in a 750 square foot space. But we can waive that requirement and expand it. Honestly, unlimited, but, you know, that's why we're a board that can, you know, set a standard.
Well, that's the whole point of having a board, especially one named appeals.
I agree. I mean, this is
You
the,
can write laws that hem you into a corner that you can't escape from.
and that is the, you know, the purpose of the Board of Appeals is to respond to the practical matters of,
But isn't
Specific.
our goal to enforce what is written in terms of the zoning for an LAA, all the requirements of it? And it's not necessarily true that what's there is what it should be. We know that the state is actively looking, many states have already done it. Massachusetts is now looking at maybe coming down with a standard that that's forced on every single town and community in the state in an attempt to alleviate the housing crisis from both an economic standpoint and a practical standpoint of available land. So, you know, I don't know, from being a resident of the town, if they came down to that, there's gonna be some community that's gonna challenge it, that's a challenge to the local zoning privileges. And then where it goes from there, who knows? You know, someone, I don't know if the state court has to get involved, but someone would have to get involved. There's nothing to say that Chelmsford has to be last in line or first in line. But it seems to be that, you know, an issue that came up tonight is about this detached versus non-detached issue. Again, whatever requirements come out of this committee, they may come out and say you don't have to be detached. They may come out and say that the unit has to be structurally of a design similar to the existing house. Or that there can be two tiers, saying that if it's up to 650 square feet, the person can do it by right, but over 650 square foot, it has to come to this board. Again, it's a big tree with lots of limbs that, you know, we had our internal talk and we just kept branching out, coming up with new things. I think that would best be handled by a dedicated group who are focused on the topic, that bring all their collective intellect on the topic to the table. I mean, I don't think it's unique to Chelmsford, but there is a overall consideration by towns similar to Chelmsford that we don't want to be Somerville and we don't want to be Cambridge. We don't want to be having all two families all over the town. Well, you're never going to look like Somerville or Cambridge. And, you know, there was a time when three families were the dominant structures that were built. The state outlawed three families. Then everything that was built is two families. with a very, dense population centers. But whether or not, people have the right, should have the right to allow others to build on their land that are connected to them or not connected to them. I think there's arguments on both sides. And that, by having a committee, you would ferret out that, and having a larger sampling of people to weigh in on it, you would have a more diverse and more accurate presentation in terms of what the town is willing to do or not do.
Can I ask, Jose, are you finding yourself turning a lot of people away for LAAs? They come in and say, I'd like to do this, and you go, it's an uphill battle, or it's a I mean, do you find that happening?
No.
There's not a lot of people saying what you're offering is inadequate for my needs.
No, I think most applicants, specifically with the 750 square feet, they seem to be okay with that size. They seem to be okay with having the doors, one door on the side, one door on the rear.
It's pretty,
Yeah.
the physical limitations are kind of,
Yeah.
they're not too onerous, I don't think.
Most of the applicants that I noticed is mostly for their parents. So, yeah.
So if you feel, and everyone's in agreement, that we can, charge you with going to the select board and saying you'd like to form a committee that would do this, I mean, I would support that,
I mean, they might say no, fine.
Right, they may.
The
they
planning
may.
board,
It's,
the same thing, the council on the aging, and so forth and so on, asking all the groups, and then I would come back and say, this was the general interpretation of whatever they had to say.
So I would make a motion to accept Glenn going to the select board and, as he sees fit, to other boards and talking and trying to put a committee together that would specifically address LAAs in town, coming up with a game plan that may be fresh and completely different than what we have now, but maybe, if we look at it, we'll find out that's what we need.
What is our perceived role in all of this? Just to get someone to go and tell the board, or to tell some planning board or whoever else that we want you to do something? Or is there an aspect where we are pushing some sort of we want this and this and this size and attachment, like, what are we being asked to do?
I wasn't offended by what we have now. I don't think it's unworkable. Glenn feels that there's a lot more that could be done. I really don't. I mean, I think our waivers are kind of a get-out-of-jail-free card. If we want 900 feet, we can have it. If, we want to waive certain requirements, we can, the design requirements, but
Is that, like, when people come in for the permit, can they ask those, I mean, if they don't know, right? You can read the bylaw, it says 750. Do they know you can expand it? Do you guys tell them
I
when they
usually do.
You do? Oh, okay.
I usually tell them.
There you go, then.
Yeah, I
All
try
right.
to inform people as much as I can.
Yeah,
That
yeah,
way
so
they-
that's great.
that way
I
they
mean, if they
their
know up
options.
front they can expand it,
the
then
one
they.
that came before us, that was like 1,400.
1,400,
That
yeah.
was extreme, and
Yeah.
I don't think necessary, in my point of view. But, if they came in and said that this is a handicap, they need a therapy room, they need, you could go
Well,
on and
900
on.
square feet, because I'm 6'3", my wife's 6'2", and we're huge.
Right, and if, you're snoring, she wants
Yeah,
quiet,
right. Right.
that you can say, okay, practically speaking, here's a plan that shows I can accomplish what I want.
Yeah.
It's still gonna it's gonna keep the side entrance, it's gonna be
Right.
correct, but it'll be, 900 feet. I would support that, most likely. I would
Mr.
think that's
Chairman.
okay.
It's not that I would go to anyone, any group, and say that the ZBA is for this. My goal would be to simply say the ZBA, which is challenged with people coming in, and in some cases, what they want is outside the current zoning. And should there be a committee set up to study this a little bit more, because it was a brand-new topic not long ago when the town, came up with whatever rules they did. But times are changing. The housing crisis
Yeah,
is
it's
different now.
been at least 10 years that these
And,
have
but
been in
not,
place.
not saying that this committee is for this or against it. It's just, we want to know what the
Willing to
feeling
look
of the
at what
town
options
is.
are available and what makes sense for our town today.
Right.
I'm curious, what else does someone want to look at? It seems like the only thing we've mentioned is the square footage. Is there something else about LAAs that someone's concerned
There's not a
about?
whole lot of other restrictions, really.
Well, the detached portion of it.
Connected to the home,
That's a
it's
big thing.
certainly a
And what
factor.
happens after the person dies? What can you do with it? Nothing?
There's
Well,
use
five
it-
suggestions in Glenn's letter, I think.
Yeah, right,
So
right.
there's 5 changes that he has proposed considering.
Well, Brian asked what kind of changes are, can be made.
Right.
And I just threw out ideas.
Yeah.
Not endorsing particularly any of them, but just saying these are all the kinds of things that need to be talked about. If you had a room if the committee was comprised of 7 95-year-old people,
Be
I
very
guarantee you would
different,
get one outlook. The idea is to get groups of multi-generational people, some old, some young, some in this financial situation, some in that financial situation, but to come out with a legitimate plan.
I think a lot of it, for me, and like I said, I think Paul and I worked on the original LAA, and we took information from other towns. We tried to put it together so it was proper. I mean, I think part of the reason it was attached is we didn't feel that two buildings on one lot, which is in violation of the building code, is, what we wanted to pursue. So we made it must be attached. But it was, it was pretty conservative. It was, so.
I mean, we had a town meeting, may have been 4 meetings ago, and you're a town meeting member as I am, so you probably heard the presentation from the Council on Aging. And then what we're trying to get is Chelmsford declared as a age-friendly town. And they they did a lot of work. It was a committee with a lot of people on it, well-written, and was presented to town meeting, and they did a nice job. The only thing was, there was nothing in there about housing for seniors. So how can you have an age-related document asking for Chelmsford to be a age-friendly community when there's absolutely nothing in there about solving the housing crisis for seniors?
Well, I think generational living is probably one of the least expensive options to caring for someone as they age.
Do we have like an aging population, like what our age group is and what our average age in the town is? I don't know if there is something like this. Do you?
I
have
think
you
the
seen
population in town is aging, but I
Yeah.
think that's statewide and.
Like what the average age of the, a resident?
Well,
here?
I think there was there was someone in town who was very much into that. And about 3 or 4 years ago, when I was on the Board of Selectmen, they were talking about how more than 50% of the people in Chelmsford would be seniors within X amount of years.
Yeah.
And it was a very short time frame.
Yeah, baby boomers, man, right?
I mean, the census
Plus
should be,
ranges everywhere.
all of this should
My
be in the
parents,
census
everybody.
pretty clearly.
I have long-term care insurance, which I bought almost 20 years ago. And
Smart man.
they set actuarial tables for what that was going to be. And at that time, it was pretty cheap. And for the last 20 years, the premiums never changed. They just sent me something that said that they petitioned the state because their expected death rate, whatever, the state granted them a small increase for each of the next 5 years. But in the documentation, they talked about what the cost would be for nursing home help and home health care and so forth. And the costs are staggering.
No, they are. My mom's in assisted living, and it is just,
Yeah, it was, I know
Numbing.
exactly. Very, very expensive.
it's
So-
unbelievable.
So
I don't know if you can buy enough insurance
You
these
know,
days to
if
cover
you
it.
were to say, if you got people that were 35 in this committee, if they were all 35s, they can't see what's going to happen when they're 70. That's why you need a mix. And no one committee has that right now, I don't think.
Hey, Brian, I'd like to disagree with you a little bit.
Oh, feel free, Chuck.
You said that you and
polite
Paul
disagreement.
wrote LAA law.
Paul was on the board, the zoning board, when I was, and I'm not saying we wrote it as much as we voted to,
Okay.
we literally decided what we were going to
Okay, 'cause-
apply to the town for. Do I have that right, Paul?
Okay.
I think the LAU was already in place. Yeah, so this was added to town meeting in 2001. But it was amended in 2010, and we were
Okay.
involved in that
Yeah,
amendment.
you guys amended it. Sue
Oh, that's what we
Carter
did,
and
we
I
actually
wrote it.
amended it.
Sue Carter and I wrote it.
And was it based
At the
on
planning
some,
board.
was it
Well,
based
that's what
on
I was
some
getting to.
template?
If we have problems
That's what I
from
was
now on,
Blame Charlie.
Okay, blame me. But I was getting to.
The mayor always knows.
Humble brag there.
I do remember working on it.
Yes.
I remember Bill
Total
Ricca
humble
was
brag.
the 750, and we said,
Right.
that sounds right, from Bill Ricca, but there were, you
Yeah.
know, we amended.
Yeah.
Okay, well, the reason I
Thank you
brought
for
that
pointing
up
that out.
is because we had the numbers, and I'm glad you guys increased the numbers. And I almost think that the numbers should be a little higher, like 800 or 900 square feet.
As we discussed, we have that ability.
Right, but,
And-
you know, one other number, maybe the number of people too in it.
So,
Maybe you could go to 3 someday.
Brian, the one thing I would caution again, any waiver that you grant from the bylaw is subject to the arbitrary and capricious standard. So like you said, you know, theoretically, you could have an unlimited increase in the size. Well, I think, you know, it's
Well,
pretty
I don't think
clear
anyone
if
on
you
the board
allow a
would support
5,000
that
square
either.
foot.
I think we all have the same feeling that the goal is to, if you want to have an in-law, you can within, but if you can come in with a strong
I guess
argument,
what I'm saying is it would be better if the bylaw specifically stated a larger number rather than you exercising discretion, because that does become, you know,
Problematic.
potential for a problem.
But I would,
You still
I
have
would
to meet
have
the
a harder,
setbacks,
I would
right?
have a harder time if
So-
this board on their own
Yes.
said it should be X, rather than having it more of an ecumenical agreement from across a number of boards who represent a diverse group. One of the problems that you have today, that you didn't have 15 years ago, is the astronomical cost of construction. You know, if you want to build one of these, let's say it's going to be $400,000, and you're going to put Mum in it, all right? And Mum dies in 4 years, and now you got this $400,000 boondoggle attached to your house that you're paying taxes on, that you can't really use because it's set up as a apartment or a house. How many people are going to be willing to do that? Throw out. If
But I
it
think
was
that's the
years ago when
decision
it
point.
was 200,000, 150,000, well, it's not so bad.
For your
But-
mom, everybody.
Yeah.
Everybody will do
But I can see Glenn's point. I mean, you look traditionally, and I know we're not traditionalists necessarily. I mean, you had a farmhouse, and older parents, you just put an addition on the back of the farmhouse, and you probably built it yourself. But times are changing that require bylaws to keep up with that. I can see his point on that. That one thing
I'm
alone.
in full support of relooking at the whole thing, the input that maybe we should consider 900 feet rather than the waiver. I mean, the waiver seemed an easy option, but, you know,
Setbacks and
I also
everything, right?
find, and maybe Jose would
Well, it's still have to-
qualify this, if you can have 900, people are going to try to put on 900.
Yeah.
So at 750, they're sort of reined in a little, even though they can say, "God, I just can't get this done," you know?
I don't think we
No
have to-
matter what, it still has to meet the setbacks, the floor area ratio, and the percentage lot coverage.
Right.
You're still limited percentage-wise based on the size of your lot as well.
Yeah, I read in there that Westford used to have a percentage of the square footage of of the original house, of the main house. But they brought that back because there were too many older houses that were too small to make it viable, and too many other houses that are too big that they,
Oh, they got caught the other way. They
Yeah.
were,
Yeah.
they were trying to limit the bigger ones, but the smaller houses that still wanted to add a little, could be 50% of, I see, yeah.
but
yeah.
you know, but,
That's
I
a good
mean,
point.
you could propose something to town meeting that says a range of 750 to 900 square feet, given these constraints, setbacks, you know, water, sewer, power availability, that kind of thing.
Right, and those all are standing on the land.
Right.
They're not part of the LAA, they're part of the property.
Right,
So they're
but still.
still effective
But still, I
tools.
mean, if you write a bylaw that can be somewhat inclusive of the various situations throughout the town, then people don't have to spend the money and the time to come to the ZBA to get it approved. That would be part of the goal, right? To lessen the burden on this committee.
Yeah, I mean, I don't find them terrible to work with.
No, but I mean, if I wanna, if
Usually
I wanna
pretty
build,
quick.
if I wanna build an LAA, I don't wanna go 3 to 5 months of approval chasing, when if it's within certain parameters, I can just build it with the Jose's approval.
I think the only ones he can approve now are without expanding the footprint.
Within the-
Those,
yes.
those can be built as of right.
Well, again, that's the kind of thing, I mean, the whole,
But if, you
Have an
know,
approval process, though. I mean, you think about that. You just, people start whacking on 750 square feet. You know,
Oh.
your neighbor might be whatever.
You
You have
you
to
know,
have
you
that.
can, you can
well,
also
Jose or his
drive,
counterpart would have to approve it,
Yeah.
You-
but still,
you can also drive through
go-
town.
through this all the time.
And how many homes will you see with additions on them? That are
I would say 75%.
1,000 square feet or more?
Oh, I don't know about that.
A lot of them might be 600 square feet, but those are okay, but building it as an LAA requires a lot of rigmarole for people, and they don't have, and if you do build the LAA, then you gotta worry about all the money you threw into it that's gone down the drain after they die, because I can't do anything with it. And I'm paying taxes on it to begin with. So we're not gonna decide, we're just not
I mean, I think
capable of
those are
doing
all
all this.
personal decisions, though.
Yeah, those are personal decisions.
You know, that
yeah.
you're gonna spend the money
And you
on your
can
mom and
convert
dad,
it
or
back
they're gonna
to-
spend the money, and then you could expand the house to make it bigger for
And
yourself.
there's a
you know,
need to
there's-
care for their
Yeah.
parents.
Right.
Whether they choose to do it at home with help, at home without help, or in a facility, none of them are good numbers. They're extremely
Yeah.
expensive. So you decide what you're gonna do that's best for your family, your lifestyle. Is someone home that's gonna be home with the parents when they're home? And, you know, it's, this is, and just, it's just a touch of it. It could be a child, autistic, it could be any kind of infirmity, and there's, it's wide open. It's not just parents. You may put one in for your child who's incapable of caring himself in the outside world, and he'll spend the rest of his life there. Be the best investment they could make. So there's a lot of different circumstances.
I have a neighbor
I mean,
like that.
I think, in my opinion, you're welcome to go to the select board and request that, we get a group together that has a lot of different views, and you can come back.
I mean, they could come back at the end and say, what we have is adequate.
It may be the best we can do considering all the, angles, but. I do think that if we increase it, that'll be the standard size. 750 is, well, we're coming to 748 or 730, or, they build it as big as they can because it's not a big number.
First apartment I ever had was only 600.
Like,
Just
If-
the
if-
one that was extreme.
but if you looked at all the LAAs we've done in the last 3 years, I would guesstimate that 99% of them are over 725 feet. People are just getting it to just under what they're allowed to have.
Right.
Because, throwing out the numbers, if you're gonna spend 400,000 on 600 square feet or 412,000 on 750 square feet, it's like,
I'd rather get what I want.
yeah,
Yep.
get the most for my
And
money.
when you're in,
basically.
you know, you're still digging a hole,
Yeah.
whether it's 10 feet big or 10 feet wide, still pouring, you know, it's all,
So I think if we told them 900, they would all come in around 892 because
I don't disagree.
Yeah.
I don't disagree, but I defer to Paul's point that you know, we're gonna grant a waiver, and then there's that issue, is it, you know, capricious? I think with cause, I wouldn't hesitate, you know, if someone, you know, oversized rooms, a large bathroom for handicapped accessibility, there's a Hoyer lift in the home.
36-inch doors everywhere for wheelchair.
Yep,
Movement.
these are all factors.
Storage, you need storage and that kind of thing too.
Yeah, yeah. So, I think you're more than welcome. I don't know if we should motion that, but you are more than welcome to go to the board of, the select board, and, you know, ask whether they'd be receptive to it, or I guess you'd probably want to talk to the other boards on your list, the planning, Chelmsford Housing Advisory Board, and see if you can get a group of people that are willing to get involved with it.
I mean, that's where most of these ancillary committees start.
Right, right,
To
yeah,
me.
it's where it begins. I
But
appreciate
I
the
would-
work you put into
I
it.
would prefer that that it's by vote, allowing me to do it rather than just,
Sure. So I'd like to make a motion to instruct Glenn to approach the other boards and the select board to create a LAA housing committee?
Thanks for that.
Second.
Well, somebody,
Who made the motion?
no, well, he seconded, but somebody has to make the motion.
I thought you just made a motion, sorry.
So I actually can make a motion. This is what I learned last week. I did not understand that. I thought as a chairman, I wasn't allowed to make a motion. So I will make that my first motion as chairman.
Wait, when did that change?
Hey, it's the way it is. Just deal with it.
It's the way it's always
I'll
been.
second it.
It was in the new book that the town passed out when you get sworn in. And it said specifically that the chairman can make a motion. I don't know why. I had it in my head you couldn't.
That's it. Here he goes. He's gonna
Right.
make emotions left
Now
and
the
right.
power, so I'm making motions left and right here, that's it. So I will make that motion.
Unlimited power, huh?
Well, it's corrupt, absolutely, right, absolute power corrupts.
He's running on batteries, there's a limit.
They're wearing down fast.
I think all
So we have a second?
All seconded.
I seconded it, yeah.
Second. All in favor? 1, 2, 3, 4, 5.
Yeah.
All opposed?
Well, can Glenn vote for himself to go to the select?
You're
Abstaining?
Abstain.
Abstaining. So the motion passes. Thank you for your time.
Thank you. Have a good night, everyone.
Paul, good to see you again. Thank you for your
Got
time.
the minutes to approve.
Please, yep.
We got minutes.
Yeah, we can let these guys sneak out, I think, without too much,
I read the minutes many times, and
Get to leave early.
they're really short, and I'd like to make a motion to approve the minutes for January 4th. As written.
I'll second.
second. Peter, all in favor?
Aye.
Opposed? None. Unanimous.
Thank you.
Good job in the minutes.
Thanks. It's a short meeting. That was an easy
It
one.
was an hour and a half.
It's not
Is that
over.
bad?
No, the previous meeting.
Meeting's not over.
No, talking about the minutes.
Didn't read
The
your
minutes
letter
were
until
from
tonight when we were
26
discussing it.
minute meeting.
oh,
I could have worked all day and I didn't come straight here.
Over two times.
Did you
get a copy of the original?
Nice.
I'll second.
All in favor?
Oh,
No second.
Okay.
Robert's rules. It's discussion only.
Yeah, it's in
Don't
here.
even need a second on that one.
Okay.
I am gonna check Robert's rules. I
We
got
are the most
1,400
restricted town in the
pages in my
area.
car, and I'm gonna see if you.
Robert's
And I-
rule, you
and
do
I-
not need a
and you're
motion.
talked about-
You need a motion to adjourn. It goes to discussion. You don't need a
The
second.
chairman making. Okay.
Your iPad?
Made him.
Rod?
Pardon?
Your
Oh,
iPad, yeah.
You had one of those.
Oh,
weird
mine.
shoes.
I got it in my